That is a Hawaii case that's been around for years that the defense is relying upon, and that based on these juror statements, I don't think the judge can really ignore. You know, they just can't. Now, grounds 3 becomes, in my opinion, this is the one that I think definitely can't be ignored. There was a live streamer, okay, texter. They don't know who, the defense did not identify who this is or the identity of this individual. But there's a live stream texter who essentially texted or put into the live stream the following message. I've been texting with one of the jurors and they're going for count 3 attempted manslaughter. This was on April 10th. The state disclosed an email from a viewer watching the trial live stream on YouTube. The chat message was posted while the jury was still actively deliberating. And the law that this defense is citing is Remmer v. United States, which states that private, and this is the same law that South Carolina just used to overturn the Murdaugh case, that private communications with deliberating jurors are presumptively prejudicial. The burden shifts heavily to the government to prove harmlessness. It's why we are having a new Murdaugh case. It's why we're going to have a new trial here. And we're going to get into just why this alone, you know, if the judge finds with this alone, the state still loses the ability to charge or to go back and retry on the second-degree red rum. But this is the important one to understand: is Remmer does not allow private communications with deliberating jurors, and we presume that that's going to have a prejudicial effect. The state has a huge burden to show that it wasn't, and I think in this case, in this context, there's no way you're going to get away from saying that there wasn't some sort of prejudicial effect. If we have jurors reaching outside the jury room, there's just no way to separate that and say that that's an untainted jury deliberation. And we're going to get into the evidence of why it seems that this is very serious. So what the defense lays out in their motion is the indicia of reliability, which is the prediction, the terminology, and the position. So the prediction predicts attempted manslaughter, nailed the highly specific unexpected verdict before it was announced. The terminology uses count 3, and the foreperson, not saying the foreperson is the one that was communicating, but the foreperson is using the word counts in later interviews, though the official forms never use that specific word because it wasn't a count. There was a list, there was a menu of options, but they were not counts, okay? They were not counts, charged counts. And the position specifies count 3. Attempted EMED manslaughter was exactly the third option on the verdict form, which was not public at the time. And that verdict form was not public. So what this means is that whoever this person was that was texting, more likely than not, you could assume had information. Now, it was argued there. If you watch our coverage, okay, we covered it. We covered the jury. Because in my opinion, the judge's the charge conference was highly important, and the judge's instructions was highly important, and we covered it. We covered exactly this. In fact, if you were a member, you would have gotten. We produced quite a bit of material on the concern that we had with how the jury was going to deal with this issue and whether or not this could cause problems, and it ultimately ended up causing problems. Now, the chain reaction. So here's what happens. First, and this is what's going to happen, and this is why the state is never going to get another shot at the attempted red rum if any of these reasons are found as a reason to give a new trial. First, the conviction is going to be vacated if the judge grants the motion on any ground. Okay, it resets it. Next is there's something called an implied acquittal. Okay, and implied acquittal means it's the case that that's being used by the defense to argue this, but the case that essentially supports this is McElrath versus Georgia, and it stands that this will stand permanently. In other words, that under the that if you have a top offense, meaning if you have a lesser that's included, and the jury is found with that, but you come back later and say, well, there's a problem with the verdict, there's a problem with the trial. Double jeopardy applies. The state doesn't get the benefit of going back and retrying the top. The top is going forever, and what's tried is the lesser. And in this case, you're going to understand it's a little bit more complicated than just this, but the step 2 is the implied acquittal. So and that is that by finding him guilty of EMED, he was acquitted of the top charge of second-degree red rum. Now, the third thing is the Whiting blockade, okay? And what is Whiting? Whiting is a case that dealt with EMED. And it says that EMED is a mitigation, not a standalone charge. So because step 2, so essentially, you can't retry, okay? He was acquitted of the top charge of second-degree unaliving. The mitigating factor, in other words, in order to get EMED, you have to be charged with the original, but the jury found that the original doesn't stand. EMED is a EMED is a lesser, or is a mitigation, but it's still considered to be a lesser of regular second-degree red rum. As a result, you can't go back and charge him with second-degree red rum. So, and the Whiting blockade says that you can't charge with EMED manslaughter because it's not a standalone charge. So this irregularity between the statutes, the way the law is laid out, does not prevent and blockades the state from going back, because they can't charge him with just standalone second degree. And the only way to get to EMED is by charging him second degree. So as a result, they're locked out because he was acquitted of standalone second degree, and thereby you can never ever again have the jury consider the issue of EMED. So they are blocked out because of this. Or it will take the appeals court to reinterpret how to deal with this situation. And better believe that the state's going to go ask that to happen. But based on how the law reads, they're saying that the lower court is going to have to find that essentially it's reversed, and the state is blocked from ever trying again for second degree unaliving, because the only way to get there is to go and charge him with second degree unaliving and then have the jury make a finding on EMED. They've already made a finding on EMED, but you can't charge him with EMED alone because you can't get there. There is no charge in the statute. And under due process laws of the 14th Amendment of the United States Constitution, I'm not sure what the amendment is in Hawaii off the top of my head, but in both of those situations, you can't create a new charge. The legislature can't go, you're not going to be subject to a charge that wasn't already present. That's unfair. So as a result, they are stuck at assault. So they're going to be stuck at assault in the first degree regardless. Now, if they find on all three of these, then they'll be stuck at it. There will be less to argue about because of 1 and 2. But if 3 is the only one the judge sides with, they're still not going to get the ability to go back and go for attempted red rum. They don't get another bite at that apple. Now, like I said, the real world consequence of this is Gerhardt Konig immediately goes from facing, at the beginning of this trial, he was facing life with a mandatory minimum of 20 years. His bail was denied because of the seriousness of those charges. Now he'll be facing a 10-year indeterminate max, meaning his max is 10 years. And the parole board in Hawaii decides when he gets released. The judge also can decide to give him probation as well. Of course, he's already served a bunch of time already waiting for trial, but bond would be highly, highly likely, and he would be able to have a GPS, passport surrender, etc. So it's very likely that if the judge finds this, he's going to grant bond, I believe, when that happens. So the architecture of this, if you can see this as and we'll show this in a bigger screen for you. You can see the masterfulness of what Otake has constructed, and that is you have grounds 1, grounds 2, grounds 3. Everything now turns on what Wong's going to do. But what's going to happen here is if any way that you grant relief on any of these grounds, it's going to potentially lead to no more than a Class B felony and a strong likelihood that Konig will be released on bond instead of what he was facing, which was up to potentially 20 years in prison. He was going to have a conviction on his record of a very serious charge, and he was going to be at the mercy of the parole board in Hawaii on when his release was going to happen. So again, this is a massive, massive, massive outcome for the defense.